Hello, I'm Dominic Walker, JMW's Inside Man, and with Paul Chamberlain. Paul is a partner in JMW's Employment Department and is the head of department as well. Hello, Paul.
Hi there. Nice to see you.
Nice to see you as well. And we wanted to talk about what the government has recently said, that they are naming and shaming businesses who have failed to comply with national minimum wage laws. They say that 191 companies have failed to pay £2.1 million to over 34,000 workers. So, I mean, what is it all about? What is the name and shaming scheme?
Well, interestingly, there has been a naming and shaming scheme for a number of years, but the current scheme's a slightly tweaked version of the original. When I've spoken to clients, interestingly, on national minimum wage issues, the thing that they've tended to be most concerned about when they realise that they might have got it wrong is not the fact that they might have to then pay some money over to the individuals who haven't received the national minimum wage, but the publicity that then flows from the naming and shaming scheme. So when the government devised it, it was really intended to encourage compliance. And I think, despite the fact that we still have lots of people on the naming and shaming list, I hesitate to think just how much longer that list would be in other circumstances. So it does what it says on the tin. You're named, you are certainly shamed if you're on that list. And I haven't seen very many people who've appeared on it more than once. So in that sense, it seems to work.
Paul, are there common pitfalls, and if there are, how should employers avoid those?
Well, there are common pitfalls. If I can start by saying the national minimum wage scheme is extremely detailed, and when we get inquiries about whether or not clients have paid the national minimum wage, we very often have to dig out the source materials, because we've got a very long Act of Parliament, we've got a series of regulations, and quite frankly, it can be quite difficult sometimes to make head and tail of those obligations. So as a result, it's very easy to fall into a pit. One of the big issues that's resulted in the list being as long as it has been is where employers think they've got a right or a legal ability to deduct from someone's pay. Well, there are only certain circumstances in which you can make a deductions from someone's pay, and to paraphrase, it tends to be where you've got an agreement with them to do it. So there's usually a clause in the contract of employment that says you can do it. But where deductions have been made unlawfully, and that's had the result of reducing pay, if you're talking about people who are being paid at or around a minimum wage, then that, of course, when you do the calculation, might result in the minimum wage not having been paid. Another one is employers not recognising when payment for hours work needs to be made. And that sounds a bit silly and obvious, doesn't it? If someone's worked, then they're entitled to be paid for it. But there are some borderline circumstances where the law says, actually, even though that time might look like working time, it's not time in respect to which the national minimum wage applies. You might remember, Dominic, there was a case recently involving care workers where they were bringing a claim saying that sleepover shifts, where they were required to be on the premises at the care home, even though they were asleep for most of that time, but in inverted commas on call, whether or not that was regarded as time in respect to which the national minimum wage should be paid, and the Supreme Court formed a view that actually it shouldn't be. So they weren't entitled to be paid for it. So there are cases which are borderline where employers genuinely do not know when they're making the payments, whether or not those payments ought to be made. But the third main pitfall is in relation to the apprenticeship rates. There are lower rates for apprentices in relation to national minimum wage, and they're not desperately well known and you can fall foul of not paying the right apprenticeship rate. That seems to be the third main area where people have fallen into the trap.
And Paul, you mentioned some of these pitfalls. How can employers avoid being named and shamed?
Well, they've got to pay the national minimum wage. That sounds simple, doesn't it? And if you say it quickly, it sounds easy. But of course, as this long list, which has recently been published, shows, it clearly isn't that easy. I mean, there are some big household names on this list. One that just immediately springs to mind is John Lewis. And John Lewis is a big organisation, a reputable organisation. I and others were surprised to see them on the list. But the problem with the naming and shaming list is that technical breaches, so not flagrant disregard for the national minimum wage, but technical breaches where calculations have just gone slightly awry, that can result in you being found not to have paid it, and therefore you're on the naming and shaming list. So what would I say is the sensible thing to do? If it's a clear-cut case, fine. If it's finely balanced and you're in some doubt as to whether or not you should be paying national minimum wage, or if you're going to make a deduction, whether or not that affects the overall rate, you should really be taking some advice. And we would say take that advice either from your lawyers or from your accountants, but get some advice, because it's too late. Once you're on that naming and shaming list, the damage is done.
Paul, thank you very much for your guidance on that. And of course, if you'd like to speak to Paul or a member of Paul's team, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.